Welcome to Court Briefs, a podcast from Paul Weiss. I'm your host, Kannon Shanmugam, the chair of the firm's Supreme Court and Appellate litigation practice, and co-chair of our litigation department. In this podcast, we analyze Supreme Court decisions of interest to the business community. Today, I'm back in my office here in Washington, and I'm delighted to be joined here by my colleague, Abby Weiss. We're going to talk about the Supreme Court's recent decision in a case called Truck Insurance Exchange versus Kaiser Gypsum Company. And if it's not obvious from the title, this is a case involving, of all things, the ability of insurers to raise objections to reorganization plans in bankruptcy proceedings. So, Abby, tell us a little bit about the facts of this case.
Absolutely. The Chapter 11 bankruptcy regime, as a general matter, allows a party in interest to raise and be heard on any issue in the bankruptcy case, including specifically the ability to object to the reorganization plan. And for asbestos-related bankruptcies in particular, Congress has created special procedures. Among those is the ability to create an asbestos-specific trust, which absorbs the debtor's liability from asbestos claims and the insurance contracts that cover those claims. The trusts have obligations to protect the interests of present and future claimants equally, including by enforcing disclosure requirements to detect and prevent payment of fraudulent claims.
So how did this case get to the Supreme Court, Abby?
Well, the parties here are Kaiser Gypsum Company, which has asbestos liability, and one of its insurers, Truck Insurance Exchange. Kaiser agreed on a reorganization plan with asbestos claimant representatives, creditors, government agencies, and its other insurers. And under that plan, asbestos claims that are covered by insurance are first funneled through the tort system and then routed to the trust for payment. And asbestos claims that are not covered by insurance are sent directly to the trust, where they are subject to the fraud-preventing disclosure requirements that I mentioned earlier. And either way, Truck is obligated to indemnify the trust up to $500,000 per claim. Truck did not support that reorganization plan for several reasons, including its claim that Kaiser and the claimants had colluded on the plan because it inequitably exposed Truck to more liability because Truck would not be able to detect fraud by the disclosure requirements in the same way that the trust could. And the Fourth Circuit held that Truck was not a party in interest within the meaning of the statute and didn't have standing to object to that plan because Truck was in the same position it was before the bankruptcy position, in that its rights and obligations under the contract were the same, and it had the same ability to detect fraud that it had before, regardless of whether the trust had new and different fraud detection methods that were available because of the bankruptcy.
So we've seen a series of unanimous decisions from the Supreme Court so far this year in business cases, and this was the latest. And the only difference was this was not a 9-0 decision, but an 8-0 decision. So Abby, tell us a little bit about what the court did.
That's right. It was an 8-0 lineup with Justice Alito recused from the decision. But otherwise, the court's decision was unanimous. In an opinion by Justice Sotomayor, the court reversed the Fourth Circuit and held that Truck was a party in interest within the meaning of the statute. The court relied primarily on the broad language of the term party in interest in the statute, as well as the statute's historical context that demonstrated Congress has consistently sought to increase participation in bankruptcy proceedings and had an overarching purpose of making those proceedings more fair and equitable and less subject to abuse by a limited number of insiders. The court explained, particularly for this case, that Truck was a party in interest because it had financial responsibility for bankruptcy claims and could be directly and adversely affected by the reorganization proceedings. And the court identified a number of specific ways in which that could have happened, but noted that specifically in this case, neither Kaiser nor the claimants had any incentive to limit Truck's financial exposure, and that in fact, the opposite incentive seemed to exist. The court rejected the notion that Truck lacked standing to object because its obligations were the same before and after the bankruptcy petition, on the ground that that kind of an inquiry belongs to the merits of the objection and not the threshold question of whether Truck had an adequate stake in the bankruptcy proceedings to begin with.
So perhaps it's not surprising that the court took an expansive view of the phrase party in interest, but Abby, what does this mean for bankruptcy proceedings going forward?
No, definitely not surprising. And I would say the most obvious effect of the decision is that parties in Truck's position have a clearer voice in bankruptcy proceedings and a clearer and greater opportunity to be involved in the structuring and review of reorganization plans. But more broadly, this case is probably best understood as another example of the court's increasingly uniform approach to statutory interpretation. And that's one driven primarily by the text, even at the cost of more inefficient proceedings. And here, the Fourth Circuit had relied on pragmatic reasons for excluding parties in Truck's position, but the court placed no weight on any efficiency savings that shortcut had provided.
Great. Well, thank you, Abby, for your analysis of this decision. And if you have any questions about the decision, please feel free to reach out either to Abby or to me. For more information about Paul Weiss's Supreme Court and appellate litigation practice, please visit us at our website, paulweiss.com. And please subscribe to Court Briefs wherever you listen to your podcasts. And if you enjoyed this podcast, please rate and review us on your favorite platform. Until next time, thank you for joining us and take care.